On proposed changes to the Foreign Intelligence Surveillance Act, or FISA, hosted by the American Bar Association. This is about an hour and 10 minutes.
Good morning. Oh my gosh. Is this on? Good morning. I'm Suzanne Spaulding, and I'm the chair of the Advisory Committee for the American Bar Association's Standing Committee on Law and National Security. And on behalf of the Standing Committee, I want to welcome you this morning. Thank you for coming to this program on reform of the Foreign Intelligence Surveillance Act. I thought I would start this morning with a very brief, very quick sort of primer on procedurally, where are we and how did we get where we are. And I think that this story sort of starts with the revelation in late 2005, December of 2005, of a program that we now call the Terrorist Surveillance Program, a program that involved electronic surveillance inside the United States without following the procedures of the Foreign Intelligence Surveillance Act, which is the statute that governs electronic surveillance collected inside the United States. Shortly after that program was revealed, Congress had a series of hearings, and by spring of 2006 was looking at legislation to try to bring some aspects, at least, of the program within the scope of the law. And those efforts were managed primarily by Senator Arlen Specter, who was then chair of the Senate Judiciary Committee. The Senate was controlled by the Republicans. That legislation did not advance significantly, and in January of 2007, the administration announced that it had found a way to bring the program within, in front of the Foreign Intelligence Surveillance Court, the secret court that was established by the Foreign Intelligence Surveillance Act, or FISA, to hear these very sensitive applications for foreign intelligence electronic surveillance. So the administration announced in January of 2007 that it had found a way to get the court to authorize basically the program activities that were described as the terrorist surveillance program. That kind of took the pressure off Congress to act until spring, late spring, early summer of that year, when the administration was back in front of Congress to point out, to explain that a FISA judge had issued a ruling, and we don't know any of the details of the ruling because these are all done in secret, but a ruling that had apparently caused concern within the administration and from public reports apparently led the administration to believe that it had to go in front of these FISA judges on a more individualized basis for each of its targets than it had been. And it had quickly led to a backup of applications in front of the court and was, according to the Director of National Intelligence, causing us to lose significant intelligence because we were not able to get up on targets. And there was an urgent need, they explained, for Congress to act. Congress entered into negotiations with the administration on legislation, and I'm not going to try to characterize that process, but at the 11th hour in August, just as the Congress was ready to leave for its summer recess, Congress passed the Protect America Act, the PAA. It was a short-term law. It was a short-term fix to make sure that that the government was able to do the electronic surveillance that it needed to do with the flexibility and agility that it said it needed. The act was set to expire in February. The Congress came back after their recess in September and got down to work to come up with legislation that was more carefully considered and was intended to be in place for a longer period of time than 6 months. The House acted first and passed its version of the FISA amendments, which it called the Restore Act, in November. The Senate Intelligence Committee very quickly thereafter passed out of the Senate Intelligence Committee, their bill. It went to the Senate Judiciary Committee. The House bill had been passed in identical form by the, or virtually identical form, by the Intelligence and Judiciary Committees, both of which have jurisdiction over this. The Senate Intelligence Committee passed its bill. It was referred to the Senate Judiciary Committee. Senate Judiciary Committee enacted some amendments to that bill, and it went to the floor. The Senate then, after a series of number of days on the floor, passed their version of the bill. And you'll remember from school how a bill becomes a law. The House passed a bill, Senate passed a different bill, and now they're in conference discussions. They're in negotiations, discussions to resolve the differences between those two bills in the hopes of coming up with a single bill that can pass in both the House and the Senate. And that's where we are today. And so we thought it was a good time to have pull this expert group together to talk about what are the issues that are in discussion between the House and the Senate, what are the most important issues, and what is the significance of those issues in terms of our dual objectives of ensuring national security within the parameters and safeguards of the Constitution and the Fourth Amendment. So we are very fortunate this morning to have a terrific group of panelists to talk about this issue. And we're going to start first with Wendy Parker. Wendy is the General Counsel and Deputy Staff Director for the House of Representatives Permanent Select Committee on Intelligence. I had the great honor of working with Wendy when I was on the House Intelligence Committee. She's been there for quite a few years. But prior to coming over to the House Intelligence Committee, she was an attorney at the Central Intelligence Agency, and she was an attorney at the Federal Bureau of Investigation, where she focused on national security litigation. She also served early in her career as an assistant state prosecutor. And Wendy's going to give us a sense of where we are currently with the negotiations as best she can, but primarily focus on, again, the key issues that are being discussed. We're then going to hear from Ken Wainstein. Ken is the Assistant Attorney General for National Security at the Department of Justice. He is the first person to occupy that position. He's been there since September of 2006. He began his career at the Justice Department in 1989 as Assistant U.S. Attorney in the Southern District of New York, and has since held a number of senior positions, both in the Department of Justice, including Director of the Executive Office for U.S. Attorneys, but also at the Federal Bureau of Investigations, where he was Chief of Staff to the Director and General Counsel at the FBI. We're then going to hear from Kate Martin. Kate has been the director of the Center for National Security Studies, which is a nonprofit human rights and civil liberties advocacy organization, and one of the few that focuses really very intensely on national security issues. She has been the director of that organization since 1992. Kate also taught strategic intelligence and public policy at Georgetown University Law School and was general counsel to the National Security Archive. She is a frequent witness on Capitol Hill, testifying in front of congressional committees on her expertise on national security and civil liberties issues, and has authored numerous publications. And then we're going to hear from Jim Baker. James Baker has had also a long and distinguished career in national security. He's a former federal prosecutor and has been engaged in lots of national security investigations, where he was on the sort of pointy end of the Foreign Intelligence Surveillance Act, trying to get authorizations approved and using them in investigations. He was with the Justice Department's Office of Intelligence Policy and Review for 11 years, from 1996 to 2007. And of course, that's the office in the department that manages the foreign intelligence surveillance process, and the applications as they go forward to the court. In May 2001, he became counsel for intelligence policy at DOJ, where he coordinated and developed and implemented national security policy on intelligence and counterintelligence matters. He received the CIA's highest award for counterterrorism achievements, National Security Agency Director's Distinguished Service Medal, and the National Security Agency Intelligence Under Law Award. He is now, or will be within a week or two, in a month, he has recently taken a position as Assistant General Counsel for National Security at Verizon Communications. So we're going to start with Wendy, giving us a sort of a status report.
Thank you, Suzanne, for the kind welcome as well as the comprehensive overview of what has happened procedurally in the House and Senate. And I would just like to backtrack a moment and perhaps repeat a couple of things that Suzanne mentioned, just to set the context for today's discussion. Again, last summer, following the passage of the PAA, the House and Senate leadership vowed to get to work immediately on long-term FISA legislation. Those who were not comfortable with the significant and broad surveillance authorities conferred on the government by the Protect America Act were given some comfort by the bill's short 6-month sunset and the fact that it didn't go so far as to confer retroactive immunity for actions of the telecommunications carriers between 2001 and 2007. The House passed its bill again in November of 2007. As the February 1st sunset date approached, congressional leaders recognized that the Senate was unlikely to pass its bill in a timely manner, so it passed a 15-day extension of the PAA, and the Senate eventually passed its bill on February 12th, 2008. Congressional leaders recognized that given the import of FISA, modernization legislation, and the differences between the two bills, there was a need to have a meaningful conference between the two chambers. Undeterred by the unwillingness of Congress to pass yet another extension of the PAA, congressional leaders allowed the PAA to expire on February 16th while noting that authorizations issued under the PAA would remain in effect until at least August of 2008. So also, in other words, coverage under the PAA could continue a year after the authorizations were signed. That included not only until August of 2008, but even into 2009 in the event that an authorization had been initiated or any existing authorizations had been renewed just before the PAA's February 16th expiration date. The Speaker of the House and the Senate Majority Leader also made clear in a February 15th statement that telecommunications carriers would continue to be covered for any support provided under existing PAA authorizations. Since that time and over the February recess, bicameral meetings at the leadership, chairman and ranking member level, and staff levels have occurred. The House could take up the bill as early as this week. At this point, Congress is indeed well postured to send an act to the President as early as next week. For additional context, I think it is important to highlight some of the similarities and the differences between the two bills. First, the similarities. First, both bills contain a more significant role for the FISA court, greater protection of privacy and civil liberties, and more checks and balances generally than the Protect America Act. Second, both bills contain prospective immunity for telecommunications carriers who comply with authorizations and court orders issued pursuant to the new statutory construct outlined in the respective bills. Third, both bills contain a lower standard for conducting surveillance than contained in traditional FISA. There is no requirement that the court engage in an individualized probable cause determination that the target is an agent of a foreign power. Fourth, both also reiterate that FISA is the exclusive means for conducting electronic surveillance. Of course, there are also several differences, and that's why we are engaged in this conference process. And I'll highlight a few that are worth noting in our limited time today. First, the House bill requires front-end FISA court review in routine, non-emergency situations. In contrast, the Senate bill allows the government to start surveillance and the government to submit the paperwork 5 days after the fact, even in routine cases. Second, the House bill does not change the definition of electronic surveillance. In contrast, the Senate bill significantly modifies that long-standing definition by carving out a broad exception that says that electronic surveillance does not include targeting of a person reasonably believed to be located outside of the United States, irrespective of who that person may be in contact with or where the surveillance may occur. Third, the House bill requires the DOJ IG to lead the review of the President's terrorist surveillance program and similar warrantless surveillance programs. In contrast, the Senate bill requires no such review. Fourth, the House bill requires the establishment and court approval of guidelines to ensure that reverse targeting does not occur, and that spell out when a traditional FISA order must be sought. In contrast, the Senate bill does not require guidelines, but it does say that this new authority cannot be used to engage in reverse targeting against U.S. persons located here in the United States. Fifth, the House bill requires quarterly compliance assessments by the FISA court. The Senate bill, in contrast, does not mandate those compliance assessments. And finally, the sixth point is that the House bill confers no retroactive immunity. The Senate bill, in contrast, does confer retroactive immunity on telecommunications carriers who may have been engaged in supporting government efforts between September 2001 and January 2007. And with that, I think I'll turn it over to Ken.
Okay, thanks, Wendy. Good morning, everybody. First, I want to thank the ABA and thank Suzanne for holding this. I think the topic here is obviously of great current importance, but I like the approach that we're taking, which is let's look at the merits here. Let's sort of strip away some of the atmospherics that we see highlighted in the newspapers and sort of focus on the merits of the debate. And what I'd like to do is following in that vein, I'd like to focus on the Senate bill. The Senate bill that was voted out, Wendy just described it to you. And I think, as you know, that's a bill that passed with an overwhelming bipartisan majority. I think it was 68 to 29. And there's a reason why it passed so convincingly, and that's because it's a quality piece of legislation. And I think if you look at the legislation and you look at the process that led to that bill, you see how sound a piece of legislating that was. So what I'd like to do is I'd like to go back to the beginning and sort of walk through the evolution of that bill, because I think if you do that, you see how strong it really is. And to go back to the beginning, Suzanne started at 2005 in the legislative process. I want to go back to FISA, 1978. Very briefly, just to remind everybody to put this in context of what this is all about. FISA passes in 1978. It creates a dichotomy between targeting surveillance inside the United States, which has to go to the FISA court, gets protections versus targeting at persons overseas outside the United States. FISA did not intend for us to have to go to the FISA court to get approval before doing that. Unfortunately, unfortunately now in retrospect, the bill was drafted in a way that was technology dependent. They actually used certain types of technology in defining the jurisdiction of the FISA court. As we know, since 1978, the communications technology has dramatically changed, and the result is the jurisdiction of the FISA court, with the change in technology, has expanded so that we have had to go to the FISA court to get approval to target persons overseas for surveillance, which is not what was contemplated by Congress. Operationally, what has that meant to us? It's had a number of very important implications. First, as I said, it means we have to go to the FISA court to get approval before we target somebody outside the U.S. It means we have to establish probable cause that the target is a foreign power or an agent of a foreign power. Rather than simply showing that we have a legitimate foreign intelligence purpose to target that person, which is what we've historically had to do, instead we have to show probable cause. And keep in mind what that means. And by the way, let me step back for a second. I think there's consensus on this, that this is a fix that is necessary, but it's important to sort of lay this out as context. What this means is that we have to show probable cause that a person overseas is an agent of foreign power before we can surveil that person, listen in on his telephone calls or monitor his email traffic. That's a higher level of protection that American persons walking down the street have against a police officer stopping and frisking them. So I think that sort of puts it in perspective that we're granting a higher protection to terrorist targets overseas for electronic surveillance than we are for stop and frisks of American persons here on our streets. The implication of all this is that we used valuable agent, attorney, analyst time developing probable cause, putting together FISA packages, slowed us down, and it meant that in many cases we were completely precluded from doing legitimate surveillance overseas because we just could not establish probable cause. Definitely a good foreign intelligence purpose to go up in a surveillance, but we couldn't make PC. So even though we had emergency provisions in FISA, we still were not, that still meant if we didn't have PC, we couldn't go up into surveillance, and even if we did, we had to show PC to the Attorney General, the satisfaction of the Attorney General, and produce a FISA package within 72 hours. A lot of work that was unnecessary and never was contemplated by Congress. This was, I think we all agree, an unacceptable state of affairs, only became more unacceptable after 9/11. Congressional action since 9/11 you've gotten a good summary so far from the previous two speakers. Bottom line, summer of 2006, Congress really kicks into action. There are hearings, a House bill gets passed but doesn't end up becoming law. Spring of 2007, the administration proposes its FISA modernization proposal, which does three general things. First, it establishes a carve-out for targeting surveillance overseas. It says that's not subject to FISA. It does that by redefining the terms in FISA. It has a number of streamlining provisions to make FISA easier to use, and then adds a number of enhancements to FISA. And then the third thing that it did is it provided immunity to providers who assisted the government in the aftermath of 9/11. So that's spring of 2007. There are a series of hearings held, and then in the summertime, the National Intelligence Estimate comes out, the threat level goes up, or the threat environment goes up. At the same time that we have an intelligence gap caused by the fact that we can't do these surveillances overseas that we need, and then Congress steps up and responds with passage of the Protect America Act, and I applaud Congress for responding to the need. The Protect America Act really does not do anything. It doesn't address immunity, doesn't address all the other enhancements that we sought in the administration proposal, but it does give the foreign carve-out. It says that we can do programmatic surveillances against persons overseas, and within days of that passage, the intelligence gap, or the passage of that statute, the intelligence gap that we had identified that was so troubling was filled. So then, fall of 2007, Congress comes back in and kicks into high gear. The House holds hearings and then produces a piece of legislation that, from the administration's perspective, really fails to address the concerns that we have. As Wendy said, it continues to require FISA court pre-approval. There's an emergency provision, but still requires pre-approval before going up on surveillance. Does not include immunity. Limits the types of surveillance, limits the type of foreign intelligence that we can get by using these authorities. And as a result, the White House announces that the President's advisors would recommend a veto if that got passed. Now, the Senate Intelligence Committee rolled up their sleeves and really jumped in, and I think took a lead role in this process. They examined every issue. They put out a strong piece of legislation, voted out 13-2, included a very well-reasoned report. Went to the Senate Judiciary. It was fully debated on the floor and then got passed 68-29. And I think it's worth taking a minute, and you see I'm focusing on the process here. I think it's worth taking a minute to look at the process because it was a long and tedious one, but I think it was a very healthy process. It was legislating as it really ought to be. You know, the members were getting immersed in the issues. There were lengthy, substantive debates. We were up there on a daily, hourly basis debating these issues with members and staff. They really looked hard at the civil liberties implications. They engaged with outside parties. There was a full spectrum of opinion on the table. Lots of compromise being done on every issue. There were maybe a dozen or so hearings, a total of somewhere in the range of 44 different amendments by my count, give or take a few. 44 different amendments were proposed and debated between committee and the floor, and I think there were around 39 or 40 recorded votes held throughout the process. A very comprehensive, thorough process, reflected well on Congress and reflected very well on the ultimate legislation. The bill, let me just hit the main things that the bill does. It hits all the important bases. Gives us the collection capability we need by giving us the foreign carve-out under FISA. Gives targeted immunity to providers, which I think we'll talk more about this. That was a fully debated issue. The question was whether the providers, the communications providers who assisted the government since 9/11 did so in good faith. The Intelligence and Judiciary Committees saw the documents and the assurances that the providers received at the time that they assisted us and determined, and the Senate Intelligence Committee put out a very well thought through report on this issue, and they determined that they did act in good faith. There was no reason to keep them subject to liability, and that in fact doing so would show their cooperation in the future, cooperation which is absolutely vital to our ability to do surveillance. Also, in addition to the collection capability, in addition to the immunity, the Senate bill has a host of provisions which provide limits and safeguards well beyond what were in the Protect America Act, provides for significant oversight by the FISA court. The FISA court reviews our targeting procedures, the procedures by which we determine a person is overseas and therefore can be surveilled without going to the FISA court. Reviews our minimization procedures by which we protect U.S. person information. It receives reports from the AG and the DNI, the FISA court does, on a regular basis. And for the very first time, the FISA court will have to approve our surveillance of a U.S. person overseas before we do so. That was not the case before, that is not the case now, and that's a big change. It provides a lot of protection to United States persons. It also provides for substantial congressional oversight, and I think importantly, the Senate bill addresses many of the, I think actually all of the main concerns that were raised about the Protect America Act, the concern about reverse targeting, the concern that we might collect information about an American person in the United States because it relates to a person overseas. It actually raises the standard of review, lowers the standard of review by which the FISA court reviews our targeting procedures. It used to be clearly erroneous, now it's a de novo, so we have stricter review from the FISA court. So the result is a very strong bill. Gives us the tools we need to do our surveillance. Gives the providers the certainty they need so that they can feel comfortable going ahead and assisting us in our surveillance efforts, and gives the American people the limitations, protections they need to make sure that, or to feel confident that this surveillance program is being done with due regard to civil liberties. It's important that this bill get passed. It's particularly important now that the Protect America Act has expired. Been lots of talk about what the implications of the expiration are. Bottom line is that we need a sound piece of legislation. We need to put our surveillance program on a solid footing to go into the future in the war on terror, the war on our efforts against foreign spies, and to protect the national security. The Senate bill provides that solid footing, and for my money, that's the bill that should be passed. Thank you very much.
Thank you. Ken thought I was going to say ditto, but I don't think I am.
Persuade you, huh?
I do want to thank the Standing Committee and Suzanne, though, for this opportunity, which I think is sorely needed given the public debate so far. And I especially want to express my appreciation to Ken for agreeing to engage in a debate, which has not been true of many of the administration spokespeople. But so I'm going to exclude Ken from the comments that I'm going to make just briefly, because I do think that what's been said publicly is relevant to how we continue in this debate. And I just want to make a couple of points. It is, and I think almost everyone in this room would agree and knows quite well, bad for the intelligence community as well as bad for the constitutional processes, I think, in this country for intelligence methods and laws to be made a matter of partisan political debate. And that has been done by this administration ever since the time that Attorney General Ashcroft took to the television cameras to say that the Senate would have blood on their hands if they didn't pass the Patriot Act tomorrow, all the while when we later learn that the President's lawyers are drafting executive orders that will allow the President to avoid all restrictions in the Patriot Act on indefinite detention and surveillance. I think that the failure to be straight with the American people about what's in the bill, the reasons for the bill, the necessity for the bill, the issues raised for the bill has had a deleterious effect on the public debate, and eventually it will have one on, if it hasn't already, on the public confidence in the workings of democracy, and more importantly, perhaps for this audience, on the integrity of the intelligence services, and that will be bad for the intelligence community in the long run. This debate and this bill is not about terrorist surveillance. It's not, as the President claims, and as I heard Representative Lamar Smith yesterday claim, that without the Protect America Act in place, the government cannot listen to Osama bin Laden calling someone on their cell phone unless they know that who Osama bin Laden is called. That claim was made on the radio just yesterday. So I want to talk about what it is about and focus primarily on the differences between the various bills on the requirement for a court order for surveillance. As Wendy said, the House bill requires prior court authorization of the surveillance covered by the bill. The Senate bill requires after-the-fact court review of the targeting procedures used by the government, not after-the-fact court authorization of the surveillance. And both of those need to be contrasted, I think, with what the FISA originally required before the Protect America Act. First of all, on the question of the carve-out for overseas surveillance, in the House bill is a specific provision that says very plainly any conversations or communications between two individuals reasonably believed to be located overseas are not governed by the Foreign Intelligence Surveillance Act. That seems a reasonable way to ensure that the government is not hamstrung and Americans' privacy is then protected by the FISA itself. Secondly, the surveillance that's at issue here is, and we have to remember this, surveillance of telephone conversations and email communications between individuals located overseas and Americans and others located in the United States. And it's surveillance of using the telecommunications infrastructure located in the United States. It's surveillance under which the government goes to the telecommunications companies located in the U.S. and asks for access to their facilities. It is what has classically been understood as the core of the Fourth Amendment. It's the government acquiring the communications of Americans, talking with people overseas, and doing so from U.S. telecommunications facilities located in the United States. And while we can debate what the standards should be, we should start with that understanding, I think. It covers not only acquisition of the contents of those communications, but it covers pen register and trap and trace information. It is not limited to conversations by terrorists. In fact, it's not limited to communications relating to terrorism, despite the rhetoric of some other administration officials. The amendment that was offered in the Senate by Senator Feingold to limit it to terrorism was vigorously opposed by the administration. Now, what FISA had required, of course, was a court order based on probable cause if you wanted to go to the telecommunications facilities in the United States and knowingly acquire the communications of an American with someone overseas. The House bill does not require that. It doesn't require probable cause. It does, however, require court authorization. And I think that we can discuss this at more length, but it's interesting to me. If you look at the practical effect of requiring prior court authorization, is that the first practical effect of doing that is that the telecommunications providers will have nothing to worry about. Their worry about being sued stems solely from the fact that since 9/11, the President and his advisors have gone to the companies and said, please give us access to your facilities in the United States without a warrant, from which we will take communications by Americans. And that's what they've been sued about. If they had had a court order, and if in the future they have a court order, they can be sure that they will not face liability for assisting the government in what everyone agrees is necessary and lawful surveillance. But secondly, the court authorization, I think, is important, and I'll end with this point, because this is something I think that has not been discussed enough, is not simply because a court's involvement ensures that the rules that apply to the surveillance are being followed. We in the civil liberties community, in fact, don't think that the rules in the House bill are protective enough of privacy. But court authorization plays another very important role, which is that, as I read the Senate bill, the DNI and the Attorney General are given the authority to go directly to the telecommunications providers and say, we are targeting al-Qaeda, we are targeting these individuals overseas, and give us access to your facilities so that we may take from the stream of communications going across the network those communications which we believe are necessary to carry out our legitimate foreign intelligence purposes. Under the FISA and under a regime that has a court authorization of surveillance, the court issued an order to the telecommunications providers which said, give the government access to the following communications. Give the government access, or whatever kind of access they need, in order to get everything from this area of Pakistan. But it did not say, give the government access to the telecommunications infrastructure. And if, as I believe it does, that's the effect of the Senate bill, we are looking at a revolutionary change in the way the government conducts surveillance of Americans.
Well, thanks very much. I also would like to thank the Standing Committee, the ABA, and Suzanne for setting this up. It's again, as everybody said, it's a very important event, and important that we keep discussing these issues to make sure that there's as much information out there so that the decision makers, the American people, and Congress and the administration can make informed decisions on these issues as we go forward here. So thank you very much. And just to also clarify, I'm speaking here today in my personal capacity, and anything I say does not necessarily reflect the views of my future employer. So, on any topic. All right, so to try to, one of the disadvantages of going last is everybody has said a lot already, so let me try to just make a couple of points here I know Suzanne wants to move to questions as quickly as possible. So let me just say at the outset one thing that I do worry about. I worry about for the future in terms of, and when viewed from the perspective of the FBI agents in the field and investigators and analysts in the intelligence community, I worry about the complexity of the legal structure that we are now creating with respect to collection. And in the context of content collection, which is really what we're talking about here today, we're talking about full content collection. And in the context of non-content collection. So what I mean by that, content is, what you actually say on a telephone call or what you actually say in an email. And non-content is the dialing information or the routing information about your email. It's the stuff about your communications versus what you're actually saying in the communication. And so, if you look at it, you've got now what you're going to have. One of these bills is going to pass, I assume. You've got regular FISA electronic surveillance. You've got FISA physical search. You'll have the new bill that we have today. You'll have, if the Senate bill passes, you'll have 2 different regimes for conducting electronic surveillance of U.S. persons overseas. Plus, there's sort of an exception to that where you don't have to go to the court if you're actually going to conduct electronic surveillance if you've already got a FISA court order. You've got FISA pen register, trap and trace authorities you can get. You've got FISA 215. 215 starts to get into the Section 215 of the USA Patriot Act. That gets into non-content. And then you've got national security letter statutes, and you've got grand jury subpoenas, and you've got a variety of other ways to collect the non-content. And I guess what it seems to me that we need to resolve the issues that Ken and Wendy were talking about, and Kate, in the short term, but that for the longer term, we still have a job ahead of us, and the job ahead of us is to bring some clarity to this, to go back to the drawing board, rethink a lot of these issues very fundamentally, and come out with something that's clearer for everybody, both for the investigators who are trying to protect you, both in terms of your safety and your liberty, as well as everybody who's concerned about what the government is doing, so that we can understand what's happening, that there's clarity, we can go forward on that basis. So I think that's. If nothing else, that's something for the future, and I hope people will work on those issues as we go forward. So, okay, a couple comments about the debate. The debate, as others have said, is really about who approves surveillance before it can take place, and are we going to have courts and judges making individualized probable cause determinations before collection can begin. And to my mind, it really is not. The legal issues really aren't about technology. And technology, I think, can sometimes distract us from what we really need to be thinking about. And what we really need to be thinking about is who we want to approve these things before they can go forward. David Criss has written a nice paper for Brookings that's available that discusses a lot of these issues and traces some of the history of the technology. And so I think we should not get distracted by the technological issues, although the technological issues are pushing and driving legal determinations. But as lawyers, I think we should focus on the legal questions, and the legal question is just that: who should approve these things? Just a comment on FISA. During wartime, as I've testified before, FISA, in my mind, did work during wartime. It did produce a very substantial amount of actionable foreign intelligence that really did thwart the activities. I'm talking about traditional FISA. It really did thwart the activities of terrorist groups overseas, and was extremely, extremely productive in terms of foreign intelligence production. Okay. So going forward, it seems as though, and just sort of to categorize some of the statements that have been made here, there does seem to be, or seem to have emerged a consensus about the fact that we should base our decisions on who decides, right, because the court is the executive branch, linking those decisions to geography and nationality. And what I mean by that is, it seems to be an agreement that there should be a warrant, or something like a warrant, when you target United States persons, no matter where they are. So if they're in the United States, you should get a warrant. If they're overseas, you should get a warrant. That seems to be a bit of a consensus there. In addition, there seems to be a consensus that if you target anybody in the United States, you should get a warrant. If they're physically in the United States, you should get a warrant, regardless of their citizenship. But there also seems to be consensus that that a warrant should not be required if you are targeting somebody who's outside the United States, if they're a non-U.S. person, regardless of where the interception takes place. I think that's some of the things that Ken was talking about before. And both the House and the Senate bills, in my view, allow this kind of collection with respect to non-U.S. persons. They've taken the court out of making individualized probable cause determinations, even though the House bill has, as Kate and Wendy talked about, that there will be a court approval before the government can start collection, but it's not individualized in terms of the targets or the facilities that are going on, or that are being surveilled. This is a different judgment from the one that Congress made in 1978, because, in fact, Congress did require in the statute that if you are targeting an overseas facility and you're doing the surveillance inside the United States, you did have to get a warrant. That was pretty clear, I think, and it was in direct response to some abuses that had been uncovered in the 1970s with respect to NSA's activities and surveillance of international communications of Americans. Okay. Let me just move ahead real quick, Suzanne. I just want to clarify this one point that's been out there, and just to try to make sure that people understand. There's been statements about, well, FISA, does it require, and has it required traditionally, a warrant for foreign-to-foreign wire communications? And the answer to that is no. It does not. It has never. And that is pretty clear, I think, just from reading the plain meaning of the words on the page. And if anybody's saying that it does with respect to a wire communication, they're just wrong. That's just, I can't say it more simply than that. But the question becomes then, or another question is, well, what about foreign-to-foreign email? What about that situation? And you can read the FISA statute to require an order for foreign-to-foreign email, and let me just explain a little bit and say at the outset, really, that the way you need to think about this problem is not foreign-to-foreign email, it's really foreign-to-unknown email. It's because when you, well, let me give an example. If you are in Iraq and we capture somebody at a safe house, an al-Qaeda safe house in Iraq, and they've got an email address, excuse me, they've got an email address in their pocket on a scrap of paper. Well, what do we want to do? We want to start collection on that thing immediately, as soon as possible, through whatever legal means we've got that are appropriate. And so, and we also want to do a search of the account to see what's in there that's already in existence. When you do the search, for example, you have no idea what's in there. You don't know if it's foreign to foreign, you know if it's foreign to U.S., you don't know where it is. You have no idea. But you don't care because you want what they're talking about. And especially you want it if they are talking to the United States. If somebody in Iraq at an al-Qaeda safe house is communicating with somebody in the U.S., we want that immediately. The same thing holds true with respect to what's going on, the future communications with respect to that account. You want all those communications, and you don't care whether they're in the U.S. or outside the U.S., it doesn't really matter. And so, and the key thing is there, once you start the surveillance, you're going to start intercepting those communications before the recipient gets it. And it's only when the recipient gets the email, when they access their account from somewhere in the world, and they can do it from New York, Jakarta, or Baghdad, it's only when they access it that the other part of the equation is determined to be foreign. So at the time of the interception, let's remember, it's really foreign to unknown, because when the recipient gets it, it could be anywhere, and the stuff in the account already that's been sent, you have no idea where it is. So I just want to make sure that people are clear about that. Who approves or who should approve that kind of collection? The answer has been, as I said, it falls within the definition of electronic surveillance and search under the FISA statute, and so the court can approve that. And under the bills, under the bills that we're talking about, they both would permit this kind of collection without individualized probable cause determinations going forward. Okay. Let me just make hit two other areas really quickly. This intelligence gap, I won't go into it very much right now. Are we facing an intelligence gap right now? And I don't know. I'm not in the government right now, but I will note that the authorities that can be granted by the Attorney General and the Director of National Intelligence under the Protect America Act will exist and can stay in place for up to a year. They could have been renewed, right before the expiration that would then take us out till February of 2009. And the authorizations can be extremely broad. You don't need to specify the target. The target could be a terrorist group, it could be a foreign government, or it could be an unidentified person who possesses or communicates foreign intelligence information on a wide range of topics. These are extremely broad authorizations. They're technology neutral. There's no requirement that they listed the techniques that you're going to use, and you can arguably even have a roving directive that would be to some unknown provider if you don't know what you're going to be encountering in the future. And let me just, I guess, close with this. With respect to that issue, and going through and thinking about Suzanne's chronology and the events of the past. So, are we better off today than we were at the time of 9/11 with respect to these collection authorities? Well, from October of 01 to January of 07, we had in place 3 types of authorities to allow surveillance. It was FISA, the regular old FISA. It was Executive Order 12333, which authorizes the intelligence community to do collection overseas. And it was the Terrorist Surveillance Program. But recall that the Terrorist Surveillance Program was limited to Al-Qaeda and its affiliates and allies. So it was limited to that. And obviously, as we all know, there were no attacks during that time period. Well, what do we have today? Today we have FISA, regular old FISA, Executive Order 12333, and the Protect America Act, and the directives issued under the Protect America Act. The Protect America Act is much broader than the Terrorist Surveillance Program because the Protect America Act allowed surveillance of any terrorist group, of any foreign government, and I said almost of any person who would have foreign intelligence information. The Protect America Act, in effect, replaced the TSP, but it was much broader. So we should be better off today than we were in January of 07. So with that, Suzanne, I know you want to get to questions. I'll stop there.
That's terrific. Thank you, Jim, and thank you to all the panelists. I thought that you did a terrific job of imparting a great deal of information in a relatively short period of time, which we appreciate because we have a room full of experts here this morning. This panel could have been 3 times the size if we had taken advantage of the resources that are in this room and the people who could enlighten us as we go forward in this discussion and debate. And I know there are lots of folks who have questions, but I'm going to start by putting somebody on the spot. Who, again, was one of those people who could have been on this panel, but we had limitations of size, and that is Mary DeRosa, who's here this morning, who is the National Security Counsel for the Senate Judiciary Committee, and therefore another one of the key players in these ongoing discussions between the House and the Senate. And we heard from the House, and Mary, I wonder if you want to just give us, a minute or a couple minutes of the view from the Senate as we're going through these discussions. And
I don't know if I've got it. I will say one thing to push back a little on something that Ken said, and that is there's a lot of talk about the Senate bill and that it is a bipartisan bill, and certainly the numbers are. There were. Stand up. You want me to stand up? it is a bipartisan bill. It was a bipartisan vote, but I think that that masks the fact that many, I think all of the Democrats, probably some of the Republicans who voted for the bill, thought the bill should be improved, and we're looking to hoping to improve the bill in the process that we're in now between the House and the Senate. And so I think to suggest that there's this bipartisan bill and the House should just pass it, which is, you know, on the part of some of the Republicans in Congress, that's been their position, I think is not, and then to use the fact that it's a bipartisan bill, I think that's not a particularly fair way to portray it. I think a lot of the people who voted for, I know a lot of the people who voted for the Senate bill thought that it could be improved by adding some protections to Title I, not protections that interfere with the basic collection, which everyone agrees is necessary. And obviously, and that would include Senator Rockefeller, who's one of the major proponents of the Senate bill, but he believes that it can be improved and is looking to try to improve it in the process with the House. And on the second title, the title that has to do with immunity, there are many people, including some who voted for the bill, who have problems with that title. Senator Webb wrote a letter to the House saying, "I voted for this bill, but I really hope that you can improve it," and other senators as well. So, and on the Title II, I think the concerns of many are not, and this doesn't speak for all, but many of the opponents of immunity are not as concerned about getting the carriers as they are about the fact that the way the immunity provision is structured, it really does away with any possibility for accountability for the administration for the program, and that is the principal concern. So I guess that's the one thing I would add to the discussion.
Great. Thank you, Mary. Do we have questions, comments from the, yes?
I'm Ed Spanis from Executive Intelligence Review. On this question of immunity, or some people have called it amnesty, two problems with that are, one, the scope of the program. I mean, the question is basically, how can Congress grant, under its own constitutional responsibilities, how can Congress grant immunity or amnesty without knowing, one, the scope of the program, and secondly, the duration? I mean, there's many indications, and certainly Mark Klein's affidavits on the ATT, the secret rooms and so forth, that indicate that everything, he says everything on the internet was being vacuumed up. The entire internet was being copied. The former head of Quest says that he was approached prior to 9/11, I think as early as February 2001, by the administration and the vice president for cooperation on these types of programs, or not really specified what they were, but this also predated 9/11. So without Congress knowing the details of when this started, what the scope of it was, what else was involved, how big was it, how can Congress, under its own constitutional responsibilities, grant immunity or amnesty for something that it doesn't even know what the conduct was that it's granting amnesty for?
Well, and on a related point, there have been questions about whether Congress can really effectively legislate, even in the Title I context, of what should the surveillance authorities be, how broad should they be, and what safeguards should be in place, without fully understanding how the terrorist surveillance program came about, what exactly were the pressures on the system that caused the executive branch to react in the way that it did, such that we can avoid that kind of reaction or pressures in the future. So both, it affects both the underlying authorities as well as the immunity. And Wendy, maybe you could start by giving us a sense of what it is that Congress has, or at least who in Congress has been given access to what kind of information so far.
Right. Suzanne, I think you hit the nail on the head, and as did you, Ed. Many members in the House last year, as the House was considering the Restore Act, said, hey, we're not including immunity, retroactive immunity, because we wouldn't know what exactly we're giving immunity for. Why was that? That was because there were requests from Congress to see the documents related to the terrorist surveillance program. There were requests in place, written requests from May of 2007, and many, many follow-up requests asking for the DOJ legal opinions related to the program, the presidential authorizations, as well as the communications between the government and telecommunications carriers. But unfortunately, the House didn't have it as they were considering their bill, and so in November 2007, the House passed a bill without immunity because, again, they said, we can't give immunity without knowing what we're giving it for. The Senate, on the other hand, last fall, when considering its bill, did so armed with the first-hand knowledge contained in those documents. The Senate was, unlike the House, given access to the documents, the relevant documents, and the Senate did go ahead and decide to include a retroactive immunity provision. I would also note that it was not until late January of this year, 2008, that the House was given access to some of the key documents that I described. And it was only the House Intelligence Committee and part of the House Judiciary Committee. And it was only last week that all the members of the House Judiciary Committee were fully read into the program and given access to the documents. So this is a very important question. And again, I think that now that we have at least some members in the House read in and some members of the Senate read in to the program and who have been able to review many of the documents related to the program, we can now engage in a more meaningful debate on the question of the appropriateness of retroactive immunity and the scope of retroactive immunity, something that we couldn't do before.
Yeah, if I could, please. As to your question about immunity, or you used the word amnesty, I mean, let's just keep in mind, this is not amnesty. That's a misnomer. This is immunity. It's targeted immunity. If you look at it, you see that it's targeted to the situation we had since 9/11, and there's also a provision that allows for accounting for this similar situations in the future. So I think the Senate bill takes care of us in the past and then gives us a path to go down in the future in terms of providers protecting themselves from liability for assisting in the government. Wendy, I think, hit the nail on the head. The bottom line is that what we have here is we have the intelligence committees and the judiciary committees on both sides of Congress having gotten full access to all the relevant documents. As I said, they've seen the letters of assurance that were given to the providers that say that this has been deemed to be a lawful program at the highest levels of the government. This is authorized by the President. And they've been able to see those assurances, and as laid out in the Senate Intelligence Report, that persuaded them that this was the providers were in fact acting in good faith based on these assurances, and that's important. And ultimately, it's a policy decision here. This is not something that should be litigated by the courts. This is a policy decision that Congress can make based on their review of these documents and their understanding of what happened under this program. Keep in mind, in terms of the question about, well, how about the rest of Congress? I mean, that's one of the purposes of having intelligence committees, that they're able to have access to the most sensitive information, and that's one reason why when they issue a 13-2 vote on a piece of legislation that involves classified intelligence programs, that really means something. And in this instance, as I said, not only intelligence committees, but the judiciary committees also got access to these documents. And if I could just take advantage of having the microphone and respond to Mary's point about how far you can go with the fact that this is a bipartisan bill that came out of the Senate. And I agree with her. I don't mean to suggest that there are no concerns with that bill. There are a variety of concerns. I don't think there's anybody who thinks it's a perfect bill, including the administration. The administration made it clear that there are a number of provisions it would have preferred not to have in that bill, but on balance, that it was a sound piece of legislation that it could live with. It's something that's available to now, so they can address our need right now. And I think the fact that there are concerns on the part of probably every member up there isn't a reflection of the weakness of the legislation at all, the weakness of this bill at all. Rather, it's a reflection of the complexity of the issues and the strength of the feelings that people have on these issues and the depth of understanding that each individual member has about this. And that goes back to my point about the process here. This has been a lengthy, comprehensive process, and individual members have become expert in each of these provisions, and so I'm not surprised that they have concerns and wish that the bill could be refined one way or the other. I don't think that's a reflection of the weakness of the bill. I think the fact that there was a bipartisan majority is quite telling, given the depth of understanding on the part of those members.
I do think it's fair to say that that part of that understanding on the part of the members is the way the process works. So that, for example, Sheldon Whitehouse and others made it clear that their vote to report it out of the Senate Intelligence Committee was because they knew it was going to be referred to Senate Judiciary Committee, on which they also sat, and they would have an opportunity there to work more on improving the bill. Similarly, in terms of voting it out of the Senate, that it would go into negotiation. So I think it is, I think you're right. These are, what they reflect is that these are very complex issues, and, you know, Congress is still working their way through them. Kate, I suspect that you'd like to weigh in on the immunity or liability issue.
Well, I just want to weigh in on the what does Congress know issue, because it seems to me that the issue is not simply what does Congress know, but what do the American people know, and that we have a situation where we have a president who claimed secret power with regard to secret surveillance of Americans. We have no idea what secret powers he claimed. We have no idea what his legal reasoning was for claiming those secret powers. And we have no idea whether or not, as part of the exercise of those claimed secret powers, between 9/11 and January of 2007, some number of Americans' communications were secretly intercepted without a court order and are still being kept in the vaults of the NSA. And we don't know anything about why the FISA court said no to the president in the spring of last year, or its legal reasoning. And I see absolutely no national security reason for keeping any of that from the American public. I don't think that informing a few members of Congress is a substitute for the democratic debate that the Constitution sets up. And I think that both Congress and the intelligence community will come to rue the day when they passed an extensive rewrite of the surveillance laws that govern the U.S. government wiretapping its own citizens without even telling the American people the legal basis on which they're operating and the constitutional understandings that they are using to write those laws.
Ed?
A question for Wendy. I'd like to just sort of put out on the table, no one's discussed it, but to what extent is the Democratic opposition to the immunity provision driven by its relationship with the trial lawyers community?
I haven't met with the trial lawyers, but no, I'm just making a comment. Basically, again, as I mentioned before, I think with respect to immunity, it's important that the key members of the House and the Senate have an opportunity to debate the merits of immunity.
Information, as I understand you're saying it, that issue is now off the table.
Well, just recently, again,
Okay.
it was only last week that the full Judiciary Committee of the House gained access to the documents and were read into the program. So, I mean, again, when the House was considering its bill, it believed that it didn't have access to the relevant documents, and therefore it couldn't give fair consideration to the issue of immunity. Now, a lot of things are on the table. There are a lot of options that are somewhere between not giving any sort of immunity at all or addressing the issue, as we did in the House bill, and giving the type of broad immunity conferred in the Senate bill. And so those various options need to be debated in the context of a conference-type setting between the two chambers.
Okay. Well, I just want to point out that the trial lawyers have nothing at stake unless there's a really good case against the telephone companies for having violated the law. Such a good case that a district court's going to eventually rule that the telephone companies violated the law, and that ruling is going to be upheld by 3 judges on a court of appeals, and then the Supreme Court. And so the debate seems to me totally bizarre, because having litigated national security cases for 20 years, while I believe that the telephone companies did probably violate the law, I think the chances of that happening are really remote. But more importantly, the government's position is that they didn't violate the law, so there's nothing to worry about.
David?
I have 2 sort of comments leading up to a question for Ken. The first is the first comment is that I think there is a case to be made for FISA modernization along the lines that we've been discussing, and Jim put his finger on it, which is that in the context particularly of email, it's very hard to know the location of the parties who are communicating, and as a result, foreign-to-foreign email is within the scope of FISA, even if you know it's foreign-to-foreign, and that's sort of anomalous given the way FISA has treated foreign-to-foreign wire communications and telephone calls. The second is that the discussion, even now, I mean, years into this debate, except for Jim making that comment now, doesn't really keep up with or get to what I think is at the heart of it, which is, again, what Jim mentioned. And I think that's true for the usual reasons, I guess, the technical complexity of all this, and Ken says that Congress knows and understands that, the classified nature of the stuff, and then sometimes I worry there are other reasons, frankly, that influence it. So in an effort just to sort of move this one tiny millimeter forward, the question for Ken is, you heard Jim throw down the gauntlet. He said outright, foreign-to-foreign wire and radio communications are outside of the scope of FISA, have never been within the scope of FISA, regardless of whether the surveillance occurs in the U.S. or elsewhere. Is that true, or is that false, or you can't answer the question?
I agree with him that foreign-to-foreign was not a part of original FISA.
And has it ever been within the reach of FISA?
Well,
just limiting to wire and radio comms now.
Well, the concern is, and I think he alluded to this, that especially with email, at the time of interception, you don't know where the recipient's going to be. So carving the world of surveillance up between foreign to foreign and everything else is good in certain areas of surveillance, but for instance in email, it doesn't get you where you need to be, because at the time of surveillance, you're not going to know if it's foreign to foreign or foreign to domestic. And that's the dilemma.
That's a good and fair answer. Thank you.
Adam?
In the interest of full disclosure, my name is Adam Eisinger. I represent the Electronic Frontier Foundation, which is co-lead counsel on all of the consolidated 38 cases brought by plaintiffs, individuals, against telephone companies for violation, allegedly, of their domestic Fourth Amendment rights in light of allegations of domestic dragnet spying. Much messaging has gone on in this debate about the importance of the origins of FISA. FISA was set up in part at the behest of telephone companies, as I understand it, to provide a bright line so that when the government came to them and said, please help us, specific information was to have been provided to justify that. And if it wasn't, their statutory responsibilities were to say no. My question for the panel at the moment is, in light of that history, in light of the fact that we're talking about retroactive immunity justified allegedly by the need for prospective cooperation by telephone companies, cooperation which is compelled by statute, why in the world, in light of the fact that the House of Representatives has been read into this program for a week, must this incredibly complex, important issue be dealt with now in the context of politically, clearly very sensationalized and sensationalizable foreign intelligence gathering? Why not bifurcate these issues, allow Congress to do what it's supposed to do, be a separate, independent branch of government that safeguards individual Americans' domestic constitutional rights? Can we call a truce and conduct a policy debate independent of the FISA debate about foreign intelligence?
I guess that would be me. So Wendy moving away from the microphone there. Thanks, Wendy. Got my back. To distill that question down to why now on the immunity issue, why not deal with the collection capabilities now and worry about immunity later? First, I don't think it's accurate to say that to say that we just started this process. Yes, certain members of Congress just got the full view of all the documentation that relates to what the providers did after 9/11 and the assurances that they received. But as I said earlier, and this is a point I was trying to hammer home, this has been a process that's been ongoing for quite some time, and there are hearings about this very issue in 2006. And then again, this immunity was one of the key points of the FISA modernization package that was proposed back in, I think it was March or April of 2007. So we have debated this extensively. I've personally been up testifying about that issue for, I don't know, 6 times or so since April of 2007. So people have looked at this from all angles, both sort of the broader philosophical question of immunity and then also down to the minutia of exactly what assurances were made and exactly what the program was that the providers assisted us with. So I don't think it's, I think this is something that has been well ventilated. Also, keep in mind what the implications of not providing immunity are. As we've explained, we rely on the communications providers to do our intelligence surveillances. We can't do them without them because we, the government, don't own the communication systems. We need to rely on their assistance. And there's cooperation, there's cooperation. As you said, yes, we can compel the phone companies, we can compel the communications providers to do a surveillance that even if they litigate it, they resist a directive, we can go to the FISA court and we can get our orders enforced. Problem is throughout that time, we're dark on whatever surveillance it is that we want to go up on. So the providers are sitting there, their general counsels have a fiduciary, they're looking out for the legality and they're looking out for the litigation risk of their company. They've got a board of directors, a CEO, who have fiduciary duty to the shareholders, and they need to make darn sure that they don't do anything that exposes themselves unnecessarily. And if they've got this huge, multi-billion-dollar exposure looming in the background, they're going to be that much more risk averse, and risk aversion then leads to, we better litigate this out. And that they'd be well within their rights doing that, but I can tell you that would have a very detrimental effect on our ability to have the agility, and to have the agility to move around with our surveillances as we need to try to keep track of foreign terrorists and spies. So that's, I guess, sort of the operational reason that I see for why we need immunity now, and let's not put it off for another session.
Well, I think we'll give Ken the last word on this. I hope you'll join me in thanking our panel for a very enlightened discussion this morning.
Good job. You handled that. You handled that very
percentage of revenues attributable to society cases?
Yeah, good. Great. Thank you, Ed. Really, I mean, what, you can tell them companies are about to give him $1 billion is to settle the case?